all. My name's Keith Bray. I'm the reporter appointed by Scottish ministers to consider this application. We'll do a traditional hands up to start with that you can all hear me. So if you just give me a quick wave that everyone can hear me. That's good. And it looks as if everyone who's the lead spokesperson I can see on my iPad. I've only really got room for 9 faces on my iPad, so ideally it would be good if the lead participants remain on video and others come in and out as needed. I should have with me today the applicant, Highland Council, the National Park, SNH, John Muir Trust and Wildland Limited jointly represented, and Mountaineering Scotland. That's the list of participants that have expressed an interest in being part of the procedures, the further procedures for the inquiry. I would let you know that we're joined by Scott Ferry of the DPA. He's simply observing today. As you'll understand, this is a new type of meeting for us, and he's just wanting to observe and get a feel for how this meeting will work. He'll not be participating in the meeting, and you're unlikely to see him on the video. Our technical staff, Ewan and Callum, you've already met. They're hiding in the background should the need arise. I'm in control of the mute button, I'm told, and I'll walk you through that in a minute in terms of how the meeting might be conducted. But first I want to get you all talking, just to make sure that you're comfortable. So I'll do that by just going through the introductions. So perhaps the spokesperson for each party can just run through the introductions, who's on the line, and I'll bring you in. I do have to do a bit of scrolling here. So Mr. Trinick, you should be unmuted.
I am. Thank you, sir. Good afternoon. I'm Marcus Trinick. I'll be advocate for the applicant, whatever form of inquiry we have. I'm instructed by Nicola Martin of Wright Johnson Mackenzie, and also on the line with us, David Bell, Graham Kerr, and Imran Abbasi. Thank you very much.
Thank you, Mr. Trinick. And for the council?
Thank you, sir. My name's James Finley, Queen's Counsel. I'm appearing for both the council and Scottish Natural Heritage. But wearing my hat from the council, we have Simon Heinson, Roddy Dowell, and I think that's all. Karen Lyons may be online. And from Scottish Natural Heritage, we have Liz McLachlan, Catherine Harrier, and Debbie Green.
Okay, thank you, Mr. Finlay. For the John Muir Trust and Wildland, Mr. Kelly.
Good afternoon all, Ian Kelly, Independent Planning Consultant. I represent John Muir Trust and Wildland Limited in this case. For the purposes of this meeting, there's just myself online this afternoon.
Thank you, Mr. Kelly. And for Mountaineering Scotland, is it Mr. Gordon?
It is, yes. David Gordon, Mountaineering Scotland, and there's just me as well.
Okay, thank you very much. I heard you all loud and clear, and I'm pretty confident you all heard each other. I've muted you all again while I go through some of the preamble, if you like. We'll try to keep the mute button on. If the meeting goes well, I might unmute everyone if everyone is coming in as appropriate, but we'll start off that I'll mute you all and I'll unmute you as I bring you in. We might use the hands up facility as well. If you've used that before, you can click on the icon which allows you to stick your hand up virtually. If that's not working, please just stick your hand up in the normal fashion. we're probably going to have to be more patient than normal today with this meeting, because there'll be a bit of delay going through the commands, muting, unmuting, and hopefully there'll be no technical difficulties. You may find it useful to be on gallery view, and you'll see all the participants there. And as I said earlier, if you're the lead spokesman or speaking, be on video. But if you're not the lead spokesperson, then just switch your video off. If there's anything in the background that will make a noise, please switch it off and make sure all dogs have been walked and children have been fed, and hopefully we'll get through the meeting without any disturbances. If you want me to slow down, or if you want to pause because you're communicating with your teams or taking notes, then please indicate that by raising your hand with the function or physically. I'll not try to adopt too brisk a pace so that everyone catches what has been discussed and has an opportunity to contribute. Please be aware that we intend to make this video available on the DPA webcasting site, and it will be up in a couple of days, as I understand it, after. That will allow those who have got an interest in the case to view what has been happening at this meeting. If you have to leave for any emergency, please do not wait for permission. Please leave. If there is any emergency, just leave, and we'll understand that. Do not hesitate to leave if there is any emergencies. If a lead spokesperson is going to bring someone in, then just say that, and the person can unmute themselves and put the video on, or I can do that at this end. As I said earlier on, there might be a little bit of delay in between bringing in participants, but we'll cope with that. As you will all be aware, today's meeting is to discuss the arrangements and procedures. We won't be talking about any of the evidence or the merits of the evidence. I'm sure you're likely all to be fairly familiar with these procedures. But before we move on to the agenda proper, I assume we've all got a copy of the agenda. If you haven't, then I can't hand one out physically today, but I would like to thank you all for the constructive way that you have approached the communications to date. This is a difficult time in terms of communication, and we're feeling our way through that at the DPA. So I do thank you all the participants so far with regard to the contributions you've made in writing. That's been very helpful. So I plan to go on to item 2 on the agenda, unless anyone has got anything to say before I move on to item 2. Doesn't look from my screen that anyone is putting their hands up. So let's move on then to item 2 on the agenda. Item 2 is procedures, a code of practice for handling such inquiries, and a discussion on flexibility. The code of practice, which you may be familiar with, that provides a framework and has provided a framework for Section 36 cases in the past. It will continue to provide a framework for this case, and I'll provide a link to that in my note of the meeting. But you'll all appreciate that we may need a degree of flexibility moving forward, and cooperation between all the parties in the current circumstances. You'll be aware of our guidance, our COVID-19 guidance, which indicates that we'll try to deal with as many of the matters through written submissions instead of oral procedures at the current time, and that's where possible. If that's not possible, oral procedures are to be adapted and conducted virtually, as we are today. At the moment, there's no face-to-face oral procedures or site inspections being carried out, and many of the cases have been sisted because they cannot be progressed. You will recall you all contributed in response to a letter, an annex that was sent out on the 9th of April. And where possible, as moving forward, I would anticipate that we would continue to get your views on procedural options as we move forward. We may not be able to agree or discuss final arrangements for everything today, and I'm sure you'll appreciate that. But I hope to get a good way towards finalising the procedures for this case today. So that's what I've got to say on item 2. Does anyone have any general comments to raise with regard to the code of practice, or generally with regard to the need for flexibility in procedures moving forward? Just please indicate.
So I have nothing particular to say about that, but just that one of my party, Simon Heinsohn, his communication broke, and he's, I think, waiting in the Zoom waiting room for Ewan to let him back in. And I don't know whether Ewan is listening in while we speak, but we're very happy to proceed without him because we have 2 other members and we're in communication separately anyway. But if Ewan is
just having a look, I can't see him just now, but I'll keep an eye out for that.
Thank you, Ewan. That's fine. Otherwise, nothing else. If we have continuing problems, I'll let you know in due course if it becomes an issue.
Okay, thank you for that, Mr. Finlay. With no other comments on that I can see from the screen, we'll move on to item 3 on the agenda, which is an update with regard to additional information. I will turn to the applicant to give us an update on their thinking on the provision of additional information, and likely a discussion on the use of regulations 19 and 20 of the Electricity Works EIA Scotland regulations of 2017. These matters will likely cover ornithology, peat slide and cumulative baseline, but I do want to hand over to Mr. Trinick or his team to just provide an update and to lead into a discussion. Mr. Trinick.
Thank you, sir. Yes, there is planned additional information as follows. There will be an updated cumulative landscape and visual impact assessment to take account of events since the last information was published and advertised. We've also prepared, and we come to this later in the agenda, in fact, a response to a request for further information on peat slide risk assessment from Ironside Farrer. That our response to that request is in fact ready to submit now, as soon as you direct. Thirdly, and again we cover something later in the agenda, have sent in fact a response to RSPB on ornithology. The RSPB objection was dated 26 November 2018. RES replied to that on behalf of the applicant on 23 January 2019. There hasn't been, I'm not saying there should have been, but there's been no response to that January letter, which was also submitted to the ECU. It doesn't appear on the DPEA website at present, but perhaps it should do so. That response was resent to the RSPB yesterday to make double sure they've got it. But I'm not sure that any further work is required from us on that. But if it is, then we probably include that in the SI for regulatory purposes. In terms of the date for the CLVIA, that will be ready by the end of July for publication. And indeed, as you guessed, sir, I'm going to make a request that you treat all the information which we're going to produce as being required under Regulation 19, being directly relevant to your reaching a recent conclusion on significant effects of the development, and thereby avoiding the need for advertisement, and rather the information will be required for the purposes of the inquiry. Thank you very much, sir.
Thank you, Mr. Trinick. Are you able to confirm that all three items, as far as you're concerned, would constitute additional information for the purposes of the EIA?
Certainly the CLVI, the Cumulative Landscape and Visual Assessment will be. The response to Ironside Farrer, I think it's a matter of judgment, is the new information in there? I'm not sure there is, but I suppose a cautious approach would say you might as well treat it as if it is information required for the inquiry and additional information for EIA purposes. The response on ornithology I don't think is strictly SI. Thank you.
The response on ornithology, does it present any new analysis? Or is it too early to say that? Although you've responded already.
Sorry, my apologies, sir. I cut across you. In my view, no, sir, there is no new analysis. It's simply a response to the points raised. But ultimately, I want you to look at that and reach your judgment. But that's my view. And
just to be clear for everyone, that has been submitted. I've not seen it, but you've submitted that to the Energy Consents Unit and to the RSPB, is that correct?
On the, yes, to both on the 23rd of January 2019.
So essentially, what you're indicating there is that there is two aspects that may be treated as additional information: the cumulative landscape and visual and peat slide, and that you've indicated that there's an additional response that I should see with regard to the RSPB. On those points, are there any other contributions from any other parties? Does anyone want to provide any comment at this point? No? Okay. Well, the peat slide and an update of cumulative landscape and visual was essentially on a list that I had. So I'm actually reasonably comfortable with treating it as additional information under Regulation 19. I think that was the discussion that you're looking for. That would require, if you like, a direction from the DPA, from myself. I think it's a Regulation 19.2. It would simply ask the applicant to provide that information. I think there still is a duty to provide that information and serve it on the planning authority and any of the consultation bodies and anyone that I may see fit in terms of that information. And that would include all the parties that are present today and have indicated that they want to take part in procedures. So if everyone is content with that on these matters, on cumulative and peat slide, we could move forward on that basis. Mr. Trinick.
Just briefly, sir, in an earlier communication, you had said that proceedings would be assisted to enable consideration of this material, and you'd refer to advertisement. I mean, clearly advertisement would be needed, and I'm not quite sure why we would need assist of proceedings. If the information is delivered in July, I think that responses to that information can be adequately dealt with in the context of general timescales.
Yes, I'm now content with that, Mr. Trinick, and it would be subject to, as I said, a direction, if you like, going out and serving it on the relevant parties, and it wouldn't require public advert. And for that particular reason, there would be no need to assist the application. So I'm now quite clear on that. I think that covers off, unless there is any additional update that the applicant has with regard to the application. Is there anything else to update the parties on, Mr. Trinick?
No, sir.
Okay, right, well, I'll move on now to item 4. Those are matters which I haven't considered to be additional information for the purpose of the EIA, but there are a number of matters that I would wish to go through today with you. they were set out in my annex previously. The council has clarified one very small matter with regard to a typographic matter on their one of their letters, and that's been clarified, and I'm now very clear on the 3 reasons for their objection. The remaining areas, I was planning just to go through the remaining areas of further information that I would look for, and with your permission now, I'll just go through that. The first one was a core list of site inspections. In the first instance from the applicant, they could work together and provide an agreed list, but certainly first from the applicant. Is there any issue with the applicant providing me with a suggested core list of key viewpoints or places to visit, and that the applicant may consult with others before providing that? I would say that all of these information requests, all the parties I would plan would get an opportunity to respond to them. So are we quite content with that first request?
We're quite content with that, yes. We will provide a draft list which we will circulate to all parties, and obviously to the DPEA, seek to agree it and then submit it to you. In terms of accompanied, unaccompanied, I'll just put down a marker that we are entirely content, as and when restrictions are lifted, that you can go and visit all the non-wildland viewpoints unaccompanied. We don't have any issue with that at all. However, so far as wildland is concerned, it's an area without a lot of landmarks. You have to know where you are. It will be necessary to go quite deep into the wildland, and we would like you to be accompanied, not just, frankly, for health and safety reasons, but also so you know precisely where you are at any one time, to be accompanied by parties. Thank you.
Thank you, Mr. Drink, and we'll come on to that later on in the agenda, where I have an item on site inspections. On the next matter, if we can move on to ornithology now, I was just simply looking for a response from SNH with regard to a matter contained in the council's report on handling, I think in paragraph 8.79, with regard to contributions to the regional Golden Eagle Conservation Management Plan. Don't plan to go into that today, but it was just to get SNH's view on the requirements for that. No problem with that, Mr. Finlay?
No, as I understand it, both that ornithology and your request under European designated sites can be dealt with by SNH without any issue.
Okay. Anyone else wish to contribute on ornithology and indeed on European designated sites? Mr. Finlay has mentioned that. No. Okay, that's good. On habitats, it was really to get the applicant's response to SNH's, if you like, conditions, and to ensure that they were feasible, or at least get a response from the applicant on that. And Mr. Trinick, do you have any comments to make on that?
Yes, thank you. This is another case, I think, of a letter not reaching the DPA website. RES did respond in detail to the ECU on SNH's habitats response. The letter was dated 24 April 2019. It's not on the ECU or the DPA website. We will resend it just in case, but we know that SNH has received it because there was an email from them on the 3rd of May 2019 thanking RES for the letter and saying they didn't intend to further respond at this stage. Thank you.
Okay, thank you, Mr. Well, on that basis, what I will do is I'll review that letter and then review my requirement for that information after looking at that letter. Is that a fair way to proceed, sir?
Fine.
Okay. Next item is borrow pits. That might be even something we could chalk off today. I don't think it's necessarily going into the merits of the case, but it was just clarity whether or not the applicant was applying for the working with minerals in the search areas on the maps, or would that be something for a later application? Just want clarification on that. Mr. Trinick.
Thanks, sir. Yes, they are part of the application. EIAR paragraph 232, also figures 21A and 21B, and figure 210. Those are the references.
And Mr. Finlay, you don't have any comment on that?
Not at this stage, no.
Okay. For everyone participating, then I've heard quite clearly from the applicant, it's not really a matter, it's a technical matter. So I've heard that clearly today. So I don't think I'll be requiring that further information if everyone else is content with that. I don't see any hands going up, so that's good. In terms of traffic and transportation, aviation, I was looking for a response from Highlands and Highlands Airports Limited, just to be clear on what their response was saying. That was their last response on the 9th of July 2019 on the matter of aviation warning lights. And I would like to get Hyal's clarification on that. Mr. Trinick, do you have any comments on that?
I think we'd like clarification too. It's not entirely clear for reasons I needn't explore now.
Thank you. Anyone else wishing to contribute on that matter? No? Okay, that's great. Transport, traffic, those making representations have highlighted some matters with regard to transportation, and I would like to offer the applicant an opportunity to respond to that, unless there's correspondence again that I haven't seen. But Mr. Trinick, any comments on that matter?
Thanks, sir. Yes, there was a further letter. 25th of February 2019, a res letter to ECU, which responded to Highland Council's concerns, but also the concerns of the Stratherick and Foyers and Fort Augustus and Glenmoriston community councils. We've also, though, for the purposes of the inquiry, prepared, or at least Gordon Buchan of Pell's Frischman is in the course of preparing a response to all of the transportation issues, which will be ready to submit very shortly, whenever you direct, frankly. But I think it'd be useful to have that.
If all the parties are content, then I will leave a request for a response on traffic and transportation matters, and that will allow that to happen. Mr. Trinick, are you content with that?
Yes.
Okay. Any other party got any comment on that before we go into conditions? Okay. We're looking to try and start the process of dealing with section 36 deemed consent planning conditions and any requirement for planning obligation by written submissions. That's not to say that there wouldn't not necessarily be a requirement for a hearing at the end of the process, but to start off on the basis of requesting draft planning conditions and an indication of where those are agreed between the council and the applicant. In the first instance, give everyone an opportunity to contribute that as a party, and then see where that takes us as far as a requirement for any further procedure beyond that on draft conditions. That would be section 36 conditions and deemed consent conditions. If I could turn to the council, because I have identified the council there to kickstart that process. Are you content with what I've outlined there, Mr. Finlay?
Yes, yeah, we can circulate a draft. I think both sides, both main parties have got significant experience in this, so I don't see any difficulty in certainly narrowing things down significantly, if not agreeing them altogether.
Thank you, Mr. Finlay. Mr. Trinick.
Thanks, sir. In fact, we've commenced the preparation of some draft conditions. I'm not trying to usurp the council's function. If they want to do it, that's fine. But equally, we're quite happy to prepare the set, which is already semi-prepared.
Well, on that basis, I may amend the requirement that I ask for the information from the council and the applicant, noting where there are areas of disagreement, and then that can form the basis of a submission that others will see. Does that seem like a reasonable way forward, Mr. Finlay?
Yes, I'm grateful to Mr. Trinick for his offer, and we'll take him up on that. The only thing I would say is that given that his set is not full yet, and we'd need to respond to it and perhaps have some interaction, I would ask for slightly more than 21 days for that particular exercise. I'm not quite sure, maybe even 42 days. We've got some time to play with between now and the potential inquiry dates, and I think that would be a sensible use of time, and we'd hope at the end of 42 days to have I would imagine, a reasonably concluded document to then circulate to other parties.
Mr. Trinick.
As Mr. Finley says, we got the luxury of time, assuming a November start date. So we'll commit to preparing the set within, well, we can do it in 28 days, that's fine. And whatever the council wants by way of response period after that.
Well, based on what you've said, what I would look for then is a draft set of conditions and any draft heads of terms for a planning application from the council and the applicant within 42 days, and then that will allow that period of consultation, and then it would be open then for other parties to contribute. Does that seem sensible? I think that deals with Mr. Finley's comments and your own, Mr. Trinick. Mr. Finley.
No, I've just been informed that certainly we're keen to take as an active part in preparation of them. So it may be that both of us will produce a draft list and exchange it. But overall, that shouldn't affect the procedure that you set out.
Yeah.
I just serve notice to that on Mr. Trinick.
Just briefly, sir, if I may, there will be a Section 75 obligation offered, but it won't be ready in 28 days. So I'll ask for slightly longer to get that prepared, say 42 days.
Yeah. Okay, so it looks as if we'll be asking for that jointly from the council and the applicant within 42 days, and then further response from others. So thank you for that. Does anyone else have anything to contribute with regard to that request and the start of a process to deal with planning conditions? I did indicate that this may not be the only procedure. Once we've gone through this written procedure, there may be a requirement for a further procedure, either written or an oral process. I'm working on the basis of the additional information that, or the further written submissions that I've asked for that are not additional information for the purposes of the EIA. I think Mr. Trinick and Mr. Finlay and others would be quite keen if you get any disagreement with that to let me know just now. But I was content to move forward on the basis that those requests would not be treated as additional information. Is that fair, Mr. Trinick?
Yes.
And Mr. Finlay?
Yes.
Other parties all content with that? By the looks of things, I don't see any hands flying up, and see heads nodding, so that's good. Well, I'll amend the note of the meeting to reflect this and to reflect the timescales. I had indicated 21 days for these matters and a further 21 days, which is a little bit longer, but under the circumstances. So if we're okay for that timescale for everything apart from the last matter on planning conditions, which we agreed 42 days, and then with a response time of 21 days. Hopefully that will deal with the points by the council and the applicant. If you get any issues with those timescales, just please raise your hand or indicate. No, that's good. Okay, we're making reasonable progress. The next matter is really starting to get into the two main issues that have been identified with regard to policy and wider matters, and then landscape and visual impact, which is item 6. But we'll deal with item 5 first. When looking through the responses on my letter of the 9th of April, there are a number of the parties that are content to deal with policy, at least in the first instance, through written procedures. that is in line with our current guidance as far as COVID-19 is concerned, and my preference would be to follow that current guidance and to take matters with regard to economic benefit planning policy and energy policy forward by written submissions. I have noted that the applicant and Mr. Kelly, I think, have made some comments on that, but other parties have indicated that they would be happy to deal with those matters through written submissions. Again, like our discussion on planning conditions, that wouldn't necessarily be the end of a process if there were clear differences that are required, either further information or further discussion on, then a hearing or even an inquiry session may be scheduled. But in the first instance, my preference would be to deal with that via written submissions. But perhaps I could turn to Mr. Trinick in the first instance for a response.
Thanks. So yes, I'm afraid first time this afternoon we're probably not in perfect agreement that the applicant would like to have inquiry sessions for both socioeconomics and non-policy. However, following a useful conversation with Mr. Finlay earlier, and I'm grateful to him for the suggestion, it was his. And indeed, I think following your approach, the way forward might be to have an exchange of written submissions on both these topics at an early date, following which you and we can pick out the key areas of disagreement, the key topics that actually need to be debated, which may be few, they may be fairly focused, and then we can have inquiry sessions around those key areas, therefore not involving what doesn't need to be discussed, and cut down time that way. That's the suggestion.
Well, Mr. Finlay, could I turn to you, given you've been involved in those discussions, to get your viewpoint?
So Highland Council's and SNH's main position is that they are quite content with written submissions, but they acknowledge that this is a Section 36 inquiry and with certain procedural consequences that follow from that. Mr. Trinick wished to insist on his rights, so to speak. So with that in mind, as I understand, Mr. Trinick would, if pushed, do so. The suggestion he's made, which we did indeed discuss this morning, does seem to us to be sensible. If I can put some flesh on the bone of that, from Highland Council, its submissions on policy and socioeconomics are effectively contained in its report, and it may be, in order to set the ball rolling, that if the applicants were to produce their submissions, taking Highland Council's starting point as set out in its report, there could then be a response from Highland Council and indeed other parties that may be interested, and that may lead to a refinement of process. I'm not suggesting a timescale at the moment. There are two further issues in policy. One is, I'm not sure, and Mr. Trinick may be able to assist, it's not a matter we've discussed, the extent to which he wishes to investigate SNH's policy on wild land, which may be a separate subject. And the second matter is the National Park policy position on its park plan. As I understand it, I'm not appearing, I know I'm not appearing for the park, but the SNH witness, who I intend to call Catherine Harry, is going to deal with impacts on the park, but I don't believe she's going to deal with park policy. And so I just alert you and others to that. If there's park policy is going to be an issue, then there may need to be some input from the park. And it may be that I end up representing the park. I'm not ruling that out or in, but subject to those two issues, therefore Mr. Trinick's proposal is on balance acceptable to the council for the reasons I've indicated.
Okay, well, just dealing with the latter point first, if I can bring in the national park
Yes, sir, thank you. It's Nina Caudry here, Planning Officer for the National Park. SNH are representing us on landscape and visual impacts on the special landscape qualities, but we would be providing a policy submission in relation to the National Park Partnership Plan, which was the basis of our planning committee's decision for objection. So we would be looking to cover that aspect, but only that aspect, because other matters for other parties to make their case for.
Thank you. Mr. Trinick, do you have anything further to say after Mr. Finley's contribution? And then I will come to Mr. Kelly after that.
So just a couple I've heard what Nina's had to say about the park's position. I've got no more to add on that for the moment. In relation to wildland, offline, we're not debating issues here today, but I think it'd be useful to have a discussion with SNH about whether it's the 2007 or draft 2017 assessment guidance that will be used for the purposes of the inquiry, or indeed both. We've had that debate before, but let's pursue that offline and not trouble the reporter with the merits now. On timing of submission of draft written, our part of the draft written exchanges on policy and socioeconomics, I agree with what Mr. Finley says. We can respond to the report of handling and be the first to submit. In relation to socioeconomics, we're happy to be the first to submit, and Mr. Finley's clients can respond. I'm not offering even 42 days for that. I think I want to think about timing a bit more carefully and talk to Mr. Bell in particular before coming back to you.
Okay, so on that point, you're offering that the applicant, rather than what I had proposed was all parties provide a submission, that the applicant would provide a submission in response to the council's report of handling, then all parties would have an opportunity then to respond to that matter. It's to your submission. Is that, have I taken that correctly, Mr. Trinick?
Well, normally I would say that everyone should exchange evidence together, but actually I think it is probably up to us to state our case on socioeconomic position, particularly for this inquiry, for reasons I won't go into further here. In relation to policy, we're perfectly happy to be the first to submit and see what others have to say. After all, the purpose of the exercise, because we do want an oral session, is simply to isolate the key points that require discussion. These are not final submissions.
Thank you, Mr. Trinick. Mr. Kelly, you better unmute your mic. Sorry, I could do that if you want. Mr. Kelly.
Thank you for that. My client's position, my own position, is that there always needs to be the opportunity to put all of the evidence that is heard and in writing into a policy context, particularly in the circumstances of there being differences of view in policy. So we think there should be an oral evidence session on policy at the end, following the landscape and visual and wildland evidence. But having said that, I am quite content with the procedure that's being discussed, providing that in the time of the inquiry, you do allow at the end time for oral evidence. Thank you.
Are any of the other parties wishing to contribute? I'm conscious that Mr. Gordon shaking his head, so that's fine. Anything else? I mean, I seem to hear agreement anyway between the parties that a submission by the applicant on policy matters on the points that I've highlighted and other matters, because they're fairly broad bullet points in terms of policy and socioeconomic matters. They would submit. I've indicated a time of 28 days, but the applicant has indicated that they would wish a little bit more time. I may ask that the applicant come back to the case officer reasonably quickly on that timescale. We don't necessarily need to agree that today, but it could go in my note of the meeting. And then I have indicated a period of 28 days for everyone to respond to that. Is that a reasonable amount of time for other parties to respond to the applicant's submission? Everyone generally content with that, or should it be less, Mr. Finlay?
No, I think that should be fine. 28 days, as Mr. Trinick said, they're not necessarily going to be the final points submissions on the contentious issues anyway, so parties can bear that in mind. 28 days should be sufficient from both Highland Council and SNH. And just to let Mr. Trinick know, there will be an issue. Well, SNH are looking to apply their 2017 guidance, draft guidance, so there may be an issue on that there. So that may be something that can be covered in the policy statement from the outset as well. But 28 days is fine.
Okay. Any other party wishing to discuss that timescale? And it would be on the basis that a discussion on a further oral proceeding would take place. I think I've taken that, and you'll notice that in the next item, I think we will probably get into a discussion on a further pre-examination meeting that we should probably have in advance of an inquiry. So is it reasonable, although I'm jumping ahead and anticipating your agreement to that on the agenda, but is it reasonable that I note that after the close of this procedure, we will discuss a further oral procedure for policy matters as part of the inquiry programme? Mr. Trinick?
Yes, I think that's inevitable.
Okay, I don't see any other party raising hands or any other movements. So I'll capture all that in my note of the meeting, but just a note for the applicant to get back to the case officer with regard to the timescale for the submission of the applicant's policy submission. So we'll move on to item 6, which is discussing and looking to agree procedures to deal with landscape visual impacts on the qualities of the park and wild land. There was general consensus in the written submissions that this required an inquiry session, and so that was useful to hear everyone's views on that. There was also a suggestion on breaking up the topics, and that wasn't just from one party, that was a number of parties. I've considered that, and I have provided, if you like, some thinking on that in my Annex C to the agenda. But before we go into that, do any of the parties envisage difficulties in preparing any evidence for landscape and visual matters just now? We can't foresee what the government guidance will be, but I would like to get your views on whether witnesses are going to be able to visit sites and if you're anticipating difficulties in drawing together reports. Mr. Finlay, I think you had your hand up there.
Yes, just one in terms of my witnesses, both SNH and Highland Council, there is no difficulty at the moment with them, save in respect of the cumulative information, because as I understand it, Floych Wind Farm has just become an application, and it's just to let you and others know that there may be some delay in being able to provide a response and dealing with that, the cumulative impacts of that, depending on the timescales. But hopefully, if the inquiry is not until November, that should not be an issue. There is also need for site visits from others involved, including myself. But we anticipate with a reasonable wind and the second wave of the current crisis that site visits should not prevent the inquiry taking place in November. But there may be some delay in responding to the further information on the cumulative situation for the reason I've just indicated.
Just on that point, the direction that would go out from ourselves on that additional information under Regulation 19 would set a timescale. And I know it's jumping back onto the agenda, but we didn't actually discuss that. So if that's going to be an issue, if it's okay with the applicant, we could perhaps extend that deadline by a couple of weeks that we would normally do. So it's probably a question for the applicant, is that would you be content with a more generous deadline that I would set in any direction on the additional information that you would submit, Mr. Trinick?
So do you mean the additional information to be subject to Regulation 19?
Mr. Trinick, you just cut off there, but I suspect you were talking about Regulation 19.2 and the additional information to be required under that regulation.
Is that what you were referring to?
Yes.
Yeah, okay, fine. We hadn't contemplated that point. I think, therefore, let's stick to the end of July, unless we come back to you in 14 days after this meeting and say otherwise.
I was simply asking, once it was submitted, then the deadline for submissions from other parties after that. I think that's what the council were indicating, that they may struggle to meet normal deadlines responding to the cumulative information. So if we are talking about an inquiry in November, which we're just about to talk about, it may be useful or helpful, at least to one of the parties in the current circumstances, to just have a longer deadline for response, not for submission, but for response. Mr.
Yeah, apologies, I misunderstood. Yes, we have to be realistic here. That's absolutely fine in principle.
Okay. Mr. Finlay?
Grateful, as generous as you can be.
Okay. Well, we've discussed, or we're in the middle of discussing whether parties would have any difficulty in gathering evidence, notwithstanding Mr. Finlay's let's hope it's not over-optimistic view on where we might be in November. But does any of the parties, Mr. Gordon, would you like to contribute? Sorry, Mr. Gordon, that's you now.
Okay, thank you. Yes, it's simply that depending how circumstances go with lockdown, I may not be able to do additional field work. And since much of my field work would involve going to mountain tops in, shall we say, September or October, that may very much limit the ability to do it, since they may be cloud covered. I do have pretty good familiarity with the area. I did field work around the time of the objection. So, you know, I'm not approaching it on a theoretical or map-based basis, but you know, obviously there may be restrictions on the fieldwork I can carry out in the next few months.
Thank you, Mr. Gordon. It's really just so all the parties have a flavour for any difficulties that the parties will have. Mr. Kelly, are you aware of any difficulties that you might have?
My position is the same as Mr. Gordon. I'm familiar with the area. I have undertaken site work for this and other cases at earlier stages, but I would like to refamiliarise myself, but that will be subject to the restrictions, but we will try our best. So my position is exactly the same as Mr. Gordon. Okay,
well, just I suppose bear these comments and thoughts in your mind when we are discussing timescales. Moving on to the topics, is there agreement that there should be two inquiry sessions, one to deal with wild land specifically, which I've identified as topic 2, and topic 1, landscape, visual, cumulative of those, and impacts on the special landscape qualities of the national park, and any SLAs. Is that are those two topics, are all the parties agreed that we can have two inquiry sessions? Again, I think I'll come to Mr. Trinick first and then others.
Thanks, sir. Would you excuse me just a minute while I shut out some noise from outside? Well, can you hear that I got noise outside? You can't. Perfect. Well, I'll carry on then. I think that we need two topics, two inquiry sessions. I ask an open question to other parties whether the division between them is as set out in Annex C to the agenda. The alternative might be, possibly, and I've spoken with Finley's views in particular, whether we separate out the park and wild land, whether those two go together, or whether we put landscape and visual and the park and in one block, and just wildland in the other session.
Thank you, Mr. Trent. Mr. Finley.
So we're happy with the division as it is at present, and I can see that one could almost have a third session dealing with the park separately, but we think they would make sense together at the moment. That's our on balance view. Just so that you're aware and others are aware, for the first topic as currently designated, I would be calling two witnesses, one from the council and one from SNH dealing with the park issues. And for inquiry topic 2, I would just be calling one witness from SNH to deal with wildland. I do consider that there is a good sense in having wildland as a separate topic, because that has particular connotations and interests that don't necessarily arise in the other topics. So we see the sense in what you're suggesting at the moment.
And for the national park?
Or SNH would be representing evidence on our behalf in relation to the special landscape qualities. So I think I would defer to Mr. Finlay.
Okay. And Mr. Kelly.
Sorry, so I'm happy with the split to set out in your note, content with that.
Thank you, Mr. Kelly. And Mr. Gordon, I'm just trying to unmute you, or if you can do that yourself, that's it.
Yep. We appreciate what others have said. We find some difficulty in the split in that we look at the landscape as a whole rather than subdivided by its designations or other labels. However, we wouldn't be providing evidence specifically on wildland. So if under inquiry topic 1, we were allowed to make an occasional brief reference to wildland within the general context of landscape, visual and cumulative impacts, that would be fine, and we wouldn't actually need to take part in topic 2.
Mr. Finlay, I see you're unmuted.
Oh, that was by mistake. I'm glad I didn't say anything untoward, but no, I have nothing to add.
Finally, if I can perhaps come back to Mr. Trinick, have you got any concluding comments? It does seem to be that there is a reasonable degree of consensus that the two topics selected at the moment are sensible in terms of moving forward. Do you have any further comments?
No, I was testing the point out on a truly open basis. That's fine. It suits us because I will have two witnesses, one who will deal solely with topic 1 and the other will deal with topic 2. So it suits us.
Thank you very much, Mr. Trinick. Just on the, if you like, the running order and the parties, I've grouped them there. 4 parties, the applicant, if you like, going first, then the council, SNH and the park, and then Mr. Kelly for the John Muir Trust and Wildland Limited, and then Mountaineering Scotland. for the first topic. Does that cause anyone any problems? Please stick your hands up if that's a problem. It seems as if everyone's in agreement with that. And the order for topic 2, am I right in saying that the National Park wouldn't be part of this inquiry session, either Mr. Finlay or Ms. Caudry?
Yes, that's correct.
Okay, thank you. I got that correct. And the running order, no problems with the running order there? No, just stick up your hand if there's a problem there. You'd expect, although procedures may or may not have to be amended to meet the circumstances we find ourselves at inquiry, but you would expect the usual procedure of examination in chief, cross-examination and my questions and then re-examination. So I'm not anticipating anything different there. Is that everyone else's understanding? Just throw your hands up in the air if there's any disagreement. Okay, thank you. In terms of estimate a number of days, I'm not going to overwhelm everyone and estimate how long your evidence is on each topic. I think I just want a general feel. There's a number of experienced people in this virtual room, so in terms of identifying time for those inquiry sessions, notwithstanding there may be further oral sessions for conditions or policy. But Mr. Trinick, do you have any general views? I know we're earmarking a week and a potential rollover into 2 weeks. Do you have any, if you like, gut feel on the length of this inquiry, Mr. Trinick?
Thanks. I think that if we look at the whole inquiry, then socioeconomics and policy, assuming we narrow down to the key issues, shouldn't take more than a day, I would say, maybe less. For landscape and visual, for the 2 landscape and visual inquiry sessions, I think that will take some time, and I wouldn't want to see less than 4 days allowed for that. In terms of any other oral process on conditions, well, that won't take very long.
Thank you, Mr. Trinick. Mr. Finlay.
Slightly more pessimistic than Mr. Trinick. I think 5 days for the 2 inquiry sessions, potentially even going over to day 6. It depends how many other witnesses, or how long Mr. Kelly and Mr. Gordon are going to be, and I don't mean that in a pejorative sense, but also that there are 3 significant topics, however they're cut up, to deal with: the general landscape and visual impact, the impact on the park, and the wild land. And so I definitely think we need to set aside the 2nd week. And I would hopefully we'd finish within 5 days, but I don't think one could guarantee it.
And Mr. Kelly, does 2 weeks sound reasonable to you?
I don't think you will need the whole of the 2 weeks. I don't disagree with the general timescales mentioned so far. In terms of my client's evidence, we will be very much secondary to the main parties. And in relation to both topics, our evidence in chief would be less than an hour. So my clients will not contribute materially to the overall length of the inquiry session.
Okay, thank you. And Mr. Gordon?
Yeah, I mean, I would agree with the comments already made on the general length. In terms of our own contribution, we're with Mr. Kelly. If we last an hour, I would be surprised.
Okay, thank you very much for that. I'm assuming Mr. Finlay has covered the National Parks comments there. So we are looking at a 1 to 2 weeks, probably 7 to 8 days by the sounds of things. And I think that takes us on to that matter of dates. We had originally indicated the 2nd and the 9th weeks beginning, 2nd and 9th of November. The applicant has recently circulated a proposal to begin on the 9th of November, to allow for the prospect of a face-to-face inquiry. Do you have any availability problems on the 2 weeks from the 9th of November, assuming the applicant hasn't, but Mr. Finlay, do those 2 weeks seem okay in your diary?
They are. There may be towards the end of the. They're fine for my diary. I'm sure we can fit them in. One of my witnesses may have a difficulty on the 20th of November, but I would imagine we'll have been dealt with his evidence by that stage. So I don't think there should be any issue.
And Mr. Kelly or Mr. Gordon, do you want to raise your hand if there's anything in particular with those weeks? Happy? Well, it does sound as if we've got agreement that the inquiry should commence on the week beginning the 9th and conclude hopefully midway through that second week. Anyone disagree with that? No. So if everyone can book those 2 weeks in their schedule, I have outlined. I'm assuming that would be a Monday start. Everyone happy with a Monday start? Yep. Okay, that's good. I've tried to summarise the key points that would normally highlight in terms of documents and disclosure. There is a deliberate mistake, obviously, that I had suggested that reports were to be submitted by the 18th of October. That should have been the 18th of September, so that's a correction there. But generally speaking, an inquiry report or statement with no limit, preconditions of no more than 2,000 words. The documents, the core documents and the statements to be submitted together all electronically. And as you may be aware, there is regulations in place to remove the need for a deposit location during the current COVID-19 guidance. Whether that's in place in November or not, we'll have to wait and see. Does anyone have a concern with those deadlines? Essentially, would be, although we've moved it back a week in terms of starting on the 9th, I think I would still be keen to stick roughly to those deadlines. They're a little bit earlier, perhaps, in some inquiries, but just in the circumstances, I think it would be useful to submit on these dates. So that's the 18th of September for reports and documents, and then preconditions by the 2nd of October. Mr. Finlay, I think you're off mute.
Yes, it was just to say that, bearing in mind the point I made earlier and others have made about potentially getting access, given that the inquiry date's gone back a week, notwithstanding the point you've just made, and that it might be worth adding a week to both of those just to provide a little bit more flexibility to save parties having to come back if they've had problems with access. So I was just going to suggest we extended each by a week as the start date's extended by a week.
Anyone else got a comment on that proposal? Mr. Trinick? Oh, Mr. Kelly, your hand's up.
Yes, I would agree with what Mr. Finlay has said. I think we do need to allow for some delay in access. So I would suggest just rolling the deadlines forward a week from what you've set out. Okay,
Mr. Trinick?
I'm not sure we can tell at this stage whether that's any advantage or not. I'd be happy to keep with the dates you put in, but you know, if things change, and we have to make allowances then.
Yeah, I mean, part of the reason, if I'm being open, is with regard to some leave that I'm taking, and so I really need to be around after those are submitted. So if we do leave it another week, that might start to cross over. So my preference is, for the moment anyway, Not that we'll be going anywhere on holiday, but perhaps. But I think if we're content for the moment to stick with those deadlines, if we do need to change, because we've discussed flexibility right through our discussions today, then there will be an opportunity, as we're just coming on to discuss a further pre-examination meeting to discuss the arrangements for the inquiries. And if these dates at that point need to be changed, then we can discuss that there. So are all the parties happy that we stick with those deadlines for the moment, and hopefully that will be the deadlines that we stick to. But if there are any other reasons why we can't in terms of access and gathering evidence, then we will look at that. I'm looking for general agreement, and I think it looks as if everyone's nodding their head. So that's useful. In terms of closing submissions, that's often agreed at the end, but I've just indicated that unless we agree otherwise at the end of an inquiry session, we'll be looking for closing submissions, which obviously can cover all matters, 14 days after inquiry and 28 days for the applicant. All parties happy with that, subject to the caveat that with agreement of everyone, that could be changed in the last day of the inquiry. All happy with that? Yep, that's good. Here's the interesting bit now in terms of what we plan for. We've agreed an inquiry session for landscape and visual and the potential for other sessions. At the moment, we can't take an oral session, a face-to-face session. That may change over time. No site visits are being undertaken at the moment. My suggestion is that we plan gently at the moment for a virtual inquiry. That's the current guidance, but that we reconvene in this format to discuss the detailed arrangements in good notice and at least 8 weeks before, and it's likely it would be in advance of that, to discuss an inquiry programme and arrangements, detailed guidance for that, in light of the guidance that is in place at the time from the government. So my suggestion is that we having agreed an inquiry, that we in the first instance think towards a virtual inquiry, and if that can change over the next few months, that we go through that at a further video conference meeting and discuss and clarify how the arrangements will work, rather than planning boldly for a face-to-face inquiry and finding ourselves that we haven't done any thinking on a virtual inquiry. I'll just maybe go around the parties for their thoughts on that. And again, if I can start off with Mr. Trinick.
Yes, thanks. We absolutely agree with what you suggest. I know there will be views on virtual inquiries, but I fully support the DPEA's guidance note of 17 April, the updated version, and what it says there. The business has to keep moving. I think there are three possibilities. We have a fully physical inquiry in the normal way. Secondly, there may be a need for a virtual inquiry, but there is a third possibility, which is a socially distanced physical inquiry with some witnesses maybe appearing by video link to the location of the inquiry. So I think we have to remain very flexible until the First Minister tells us our future in this respect. And your suggestion is all we can do at the moment.
Mr. Finlay.
In general terms, I echo Mr. Trinick's view that we should carry on if at all possible. Our concern in this inquiry is that given the issues that are raised in the landscape and visual sessions, particularly wildland and others, if parties and witnesses are separate from each other, it does present considerable difficulties. If it was just the policy issues, then that would be, one could, certainly for my part, envisage a very effective inquiry session on policy issues. Dealing with landscape, visual and wildland matters, I simply perhaps place a marker at this stage that we are unconvinced as yet as to how that could be effectively dealt with, and it may well need some form of, if possible, if it is going to be dealt with, Mr. Trinick's third option to deal with it. It's not just the problem of having the witness in a different place from the person who's asking the questions. It's also having the person who's asking questions having their own witness, if you like, at their elbow, even if it's 1.5 meters away, but in the same room, confirming or passing information during the course of cross-examination. And however prepared one aims to be, and both I and Mr. Trinick have lots of experience facing each other on just these topics, in my estimation, there is a real risk that it may disadvantage a party not to have their witness present. I'm not instructed to oppose a virtual inquiry at this stage, and much rather to journey in hope or give consideration to a third option such as that which Mr. Trinick proposed. But whilst one can understand in a smaller inquiry, and as an example, Highland Council have another PM next week dealing with a pump storage facility called Red John, just to the west of Inverness, which may well be capable of being dealt with at a by virtual inquiry. But given the number of parties and the types of interests, the wide-ranging interests at issue in this case, we have reservations. I don't think we want to take it further than that at this stage, but that's our view.
Thank you, Mr. Finlay. Well, having heard the applicant and the council first off, I mean, it seems that there is consensus that things should be kept moving, but the initial preferences are face-to-face. Second preferences are physically distanced, and a third preference, but to continue the case by using a virtual scenario. Mr. Kelly, do you have any comments to make on that sort of scenario or list of preferences?
For the moment, we would agree with Mr. Finlay and leave it there. We'll just have to see how things develop. I think there's an added complication when we're all dealing with visualizations, which will be key to the landscape and visual and wildland evidence, ensuring we're all looking at the same drawing, everybody looking at the same part of the same drawing. And as I say, my overall position is one of reservations about how a virtual inquiry would work. But at the same time, we have to recognise we don't know whether we're going to meet face-to-face, so we do have to be flexible. So at the moment, I will stick with Mr. Finlay's view.
Okay, and Mr. Gordon?
We would also agree with Mr. Finlay's view, which I think you summed up yourself very adequately.
And from the National Parks point of view, although Mr. Finlay has indicated, is there anything else you'd like to add, Ms. Caudry? No. So is it fair that I would record, quite happy to, Mr. Trinick? Sorry,
yes, I just wanted to say, look, we don't know where we're going to be, but I think we need to revisit this as at an early date as possible, when we can really see what's going to happen. What we do not want, we don't want to be in the position having submitted evidence or getting close to the point and then insisting for goodness knows how long. That would be deeply unfortunate. So as early as possible. Second point I want to make is, if we do have to look at virtual inquiries, the applicant will, at the right moment, want to come back to the DPEA with suggestions to help the process with things like temporary fast broadband, where that doesn't exist for people, dual screen working, which may be an advantage, and administrative and IT assistance for the inquiry itself. There are ways we can put forward, not now, later, to try and make this work better. So yes, we recognise the difficulties, but we are extremely keen to keep to this timetable by one means or another.
Well, I've taken from what Mr. Trinick has said, and it was kind of alluded to in my note, is that we would meet and discuss these matters again before evidence, before reports, and certainly before those were submitted. And it may well be that there is a need to call another conference earlier, quite considerably earlier, depending upon the government guidance. But if you're all content that all parties are keen for the application to be moved forward, the preference face-to-face, second preference is physically distanced, and if that is at all manageable in terms of group numbers and such like. And the third option, to plan and to consider, to start thinking in the eventuality of the need for a virtual inquiry, all on the basis that we would come back and discuss in a second PEM well in advance of submitting evidence for the inquiry. Is everyone happy with that summary that I've just provided? Okay, I see everyone nodding there. I mean, the applicant has looked into potential venues for the timescale, and I thank the applicant for that, and has suggested the McDonald Hotel complex in Aviemore with regard to its size. Perhaps if I come to Mr. Finlay, is there any concern with that venue? No, it's a little bit more distant from the site, but
could I just elaborate on that first?
Yes, Mr. Trent.
People know what's on offer. Mr. Bell and I did a fairly long inquiry involving multiple parties called Altduni at that centre in 2012. In the reception building for the resort at Aviemore, the McDonald's Resort, there is a 18 by 18 metre room, a pretty substantial room where the inquiry could take place. That's where we had the inquiry then. There are also breakout rooms for as many parties as want, frankly. It's a very large building. And so social distancing is possible in that context. That's why we suggested that might be suitable. And we believe that there is availability for these 2 weeks. Thank you.
Thank you, Mr. Finlay.
No, we have no issue with that location. I acknowledge it's some distance from the site, but it's important to have a suitable size venue for the reasons that Mr. Trinick indicated. And there are other advantages for access for my witnesses from the Inverness area to be able to access it on a daily basis. So which is just that little bit easier at Aviemore than closer to Lagan, for instance. So we have no issues.
Mr. Kelly? Sorry, Mr. Kelly, I'm having trouble unlocking you. There we are.
Thank you.
If you could start again.
Thank you. I took part in the same inquiry as Mr. Trinick mentioned, and although the venue is not local, it's a very practical suggestion. No concerns about that at all.
Mr. Gordon, happy with that?
Yes, I took part many years ago in a Faculty of Public Health conference in, I think, that same 18-metre square room with well over 100 people in it. So I think we could certainly physically distance adequately.
And from the National Parks perspective, any concerns there?
No, it'd be absolutely fine for us, thank you.
No. Well, I mean, it may well be appropriate that we simply just agree that as the potential venue, and that would allow the DPA to make a preliminary booking, and I'll ask the case officer to deal with the applicant on that if everyone is content, and that we manage to get that sealed as soon as possible, and then revisit it if needs be. So thank you very much to the applicant for taking the initiative there. I had a topic for potential discussion on what we could deal with via written submissions on this inquiry topic, but I think we're all very clear that all evidence has to be heard at inquiry, so I don't intend to discuss that further All content with the standard starting times, 10 o'clock first day, 9:30 after that, looking to finish 4:30, 5 o'clock. Is there any special requirements that anyone would like to submit just now, given that it is November? We won't really know, but all happy with the general arrangements? I see everyone looking fairly content. If there is a virtual inquiry, then we will need to look at how we advertise that, and the case officer would work with the applicant and others, and also a deposit location if needs be. I don't know if the council has got any thoughts on a deposit location for an inquiry in Aviemore at the moment, Mr. Finlay?
So that's something I'd need to take instructions on, and we'll check, and we can get back to your case officer. There is a service point at the library, but the library will be closed at the moment.
Yes, but the what you could do is just ask, you know, the council to get back to the case officer in the next few days with a prospective location. Obviously, the guidance is in place just now. The regulations are in place. If you like, preclude that until those regulations are lifted. But in the event that we do meet face to face, then if you can provide a provisional deposit location to the case officer, that would be useful. I think I'm ready to move on to the next item on the agenda, which is any scope for agreed matters. Happy to take parties' views on this, but are there areas on the landscape visual wildland matters that you can easily see? Is there an appetite to look between the applicant and the council and others, perhaps to agree matters, potentially across policy as well? Mr. Trunick.
Yes, so I think clearly there is, and of particular importance in this case, for obvious reasons, to shorten the oral process. On the landscape and visual side, we can happily take a lead in drafting something and circulating it, and we'll tackle such issues as the adequacy and fitness for purpose of visualizations, methodological points, the correct documents to use for landscape impact baseline. I needn't go on. We've all been here before. We know what these points are. I think there's one additional point on wild land, which I would raise, and that is it'd be useful if we can agree which wild land areas we have to debate. That'll make a very big difference to the amount of evidence to be given and to the amount of field work that has to be done. If we're talking about just WLA 19, which I know is in play, then that's one thing. But if we're going to be asked to discuss other wildland areas, that really will increase the scope of the work to be done and potentially lengthen the inquiry. So I'll leave that for others to comment on. In policy terms, yes, of course, there's plenty of scope for agreement, but I think we've already covered that in the context of our approach to policy evidence. Thanks, sir.
Thank you, Mr. Trunick. Mr. Finlay?
Well, I believe SNH's objection makes its position clear, and I've just had it confirmed that wildland area 19 is the sole focus of its objecting. So that answers Mr. Trunick's specific query. I think there's limited progress one can make in statement of agreed matters on landscape and visual, but you can make some, and it may well be, for instance, we can agree the ground rules in respect to the visualizations and the EIA and the like, and the parties are reasonably well versed at trying to provide something for you on that to limit the disagreements. So I'm sure there's scope for it, and I'm sure that Mr. Trunick's side will no doubt put forward a draft, and we can then comment on it.
Thank you. Mr. Kelly, would you like to come in perhaps on the point of the focus for wildland matters?
I would need to take instructions on that and come back to you. I'll respond to your minutes of this meeting. I suspect the focus will be on WLA 19, but I just want to check instructions. But I would confirm very, very quickly, so there's no issue with that.
Thank you for that. But I did leave it purposely open because I'm aware that not all the representations were solely on Wildland Area 19. But if all parties were able to confirm that actually in advance of me putting out my note, then that would be probably the best situation. Mr. Gordon, do you have any comment? I know you indicated that you wouldn't necessarily be taking part in that second session, but do you have any comments to make?
No, I mean, we would, I'm looking at the map on screen, we would mention mountain areas within several areas of wildland, 19, 20, 15 and 14, but we wouldn't be mentioning them as wildland areas as such. Our concern would be the mountaineering impact.
Thank you, Mr. Gordon. So, Mr. Kelly, would it be reasonable for you to be able to get back to our case officer? Because I get the feeling from all the parties, and certainly from reading the evidence, if you were able to indicate that it was Wildland Area 19 that required evidence to be read and cross-examined, then that would allow the scope to be clarified in my note. Mr. Kelly.
Thank you, sir. I will look to do that as quickly as possible, certainly within the next few days. The only point I would make is that Wildland Limited are mainly in furlough just now, and it's actually slightly difficult to get instructions quickly, but I will pursue that and try and come back to you within a matter of a few days.
Okay, and is it fair then to kind of summarise that the parties are generally happy that topic 2 would be focusing in on area 19 unless Mr. Kelly comes back and indicates that it's broader?
Yes.
Thank you for that. In terms of agreed matters, I think I do have a sense that both on policy matters and landscape visual matters that the applicant will take the lead and seek to set out an agreed statement of agreed matters, at least with the council. Is there scope to bring other parties in? I don't necessarily need to have a discussion on that just now, but I think I would probably put it in the note that if there is scope to bring other parties in, then I would welcome that. Obviously including the park and Scottish Natural Heritage and Mr. Kelly and Mr. Gordon. Is that reasonable, Mr. Trinick?
Yes, we're happy to cooperate on that.
Thank you. Okay. Right, I don't think we need to discuss that any further then. The agreed statements, though, would probably they would be submitted at the same time as any inquiry report, I think, or for policy matters at the point where we are discussing what procedure that we're going to use before an inquiry. I think before going into an inquiry, I would like to see the agreed matters and policy matters. I don't think it would be fair to ask for that when you submit your initial response on policy matters, Mr. Trinick. But I think agreed matters and policies may well follow that. Is that fair on policy matters, Mr. Trinick?
That's fair.
Okay, thank you. Unaccompanied site visits. I have noted Mr. Trinick's suggestion earlier on. I'm also aware that most, if not nearly all, are hilltops in terms of the viewpoints anyway, that are in the landscape and visual material. Obviously, at the moment, those are not possible. Unaccompanied site visits may be more possible than accompanied in the first instance anyway. But given the nature of the case, notwithstanding a potential visit to a site or to this site, my thinking is still that unaccompanied site visits are the most pragmatic approach. If it's simply to know where I am, then I will know where I am. So you don't need to worry about that, Mr. Trinick, as far as can be reasonably estimated. I won't have a difficulty with that. But is there any other thoughts on accompanied site visits, Mr. Trinick?
So I'm sure your map reading abilities are much better than mine. You'll know exactly where you are. But having done wildland site visits, it's not that easy. And I think I'm afraid think you might benefit from having, from our point of view, Mr. Welch with you on a wildland site visit. I'm not doubting your map reading abilities and saying that.
Are there any other parties that are looking beyond a visit to the site, which may be a useful exercise to carry out as part of the inquiry? Are there any other parties who are very keen that any of the locations are visited on an accompanied basis? Just indicate by throwing the hands up, perhaps. Mr. Kelly.
Our position is relatively simple. We would be content for you to take unaccompanied site visits, but if there's to be any question of an accompanied site visit, then it's likely that somebody from Wildland Limited would wish to accompany you on those visits. But we would not insist on accompanied site visits.
Thank you, Mr. Kelly. Mr. Finlay.
Agree with Mr. Kelly that we would wish a representative to be there, obviously, but I don't imagine that would be contentious anyway. But no, we don't have a particular wish to accompany you to any particular site. But if you are going to have an accompanied site visit, either from SNH or THC or both, there will be a representative.
Okay, Mr. Gordon.
Happy to leave it to your own judgment, sir.
Okay, and from the National Park?
Likewise, we'd be going with Mr. Finlay's advice. So unaccompanied, we're quite happy for you to go where you see fit. Otherwise, if it's accompanied, we would prefer to have a representative from SNH or ourselves, depending on availability.
Okay. The draft list of site visits, the core visits that parties may wish me to make, we could certainly expand the scope of that to highlight any particular aspects or appreciation that I should have at those points, if that would assist at any agreed set of viewpoints or places to visit. That if the applicant and others agree to certain things that I should be mindful of when I'm there, then I don't have a problem with that, and that may assist. But I think my experience of visiting wildland areas with regard to wind farms is that it's more efficient, to go to the places and appreciate matters unaccompanied. We have got our own health and safety procedures in place within the DPA, so my safety should be in reasonably good hands. So I think that unaccompanied would be my proposal, and that would find its way into the note. But in terms of the site itself, Mr. Trinick, I think you've indicated that a visit to the site may be useful. I know there's not necessarily visualizations exactly from the site, but Mr. Trinick, do you think a visit to the site is important, perhaps, around the schedule of the inquiry?
I think it will be useful to you to go there, perhaps armed. We might mark out turbine locations or make sure you are otherwise aware where they are. And the purpose of the site visit would be to get some orientation with regard to the Stranraer wind farm and also the Cloyk proposal and other wind farms which may be visible from the site. I think that would be very useful.
And do all parties agree with Mr. Trinick that as part of the inquiry schedule that we should look to visit the site? I suspect we'll be coming in from the other side, and that may require a bit of coordination in terms of where parties are, and may even need an extra day or half day to be scheduled in. But are all parties happy with planning for that? Mr. Finlay?
Yes, so it seems to me that it would be sensible perhaps to plan for that prior to the November dates, partially so that you've had the advantage of being on site beforehand, and partially November weather is less likely to enable a decent site view. So, but yes.
Well, the likelihood is that I will have visited the site on an unaccompanied basis in advance, but that I would, if there is general agreement, that I would visit on an accompanied basis, obviously if the weather is providing, that around the time of inquiry. And we may have to be flexible on that in terms of schedule, given weather forecasts and such like. Ideally, it is useful to go in advance, but it's highly likely that I would visit, if not the site, very near to the site on an unaccompanied basis in advance of the inquiry, but happy to visit the site accompanied during the inquiry. Mr. Trinick, do you want to come back on anything?
No, sir. Happy.
Everyone happy that we plan for an accompanied visit to the site as part of the inquiry schedule, and that there's a bit of realisation on the need to be flexible around weather. I'm assuming, and I may be wrong, that all parties would want to be part of that site inspection. Please raise your hands if you don't want to be part of that. And is it again fair to put the onus on the applicant to potentially look at some transport and such like nearer the time, Mr. Trinick?
That's fine.
Thank you very much. Well, that moves us on. If we've concluded our discussion on site inspections, providing I don't get lost, then we'll hopefully arrange another video conference as we've agreed. I don't have much else to say in terms of any other business. There will be a need to be flexible, and I understand even from some of the comments made today that some parties may, for resourcing issues, have to withdraw from procedures or want to deal with things in written submissions, and I understand that given the circumstances and where charities are at the moment. I'll pop a email address and a link of the case officer on our notes, so everyone's aware of that, but you'll know who the case officer is. And the final point before opening it up under any other business is just to ask if there are any legal submissions to be made on this case. Please don't wait until the last minute. If there's anything in particular that you want to submit in terms of legal submissions, and delaying it in the circumstances might not be the most appropriate. But is any party anticipating any particular legal matters to be submitted? Mr. Trinick?
Not at the moment, sir, no.
Mr. Finlay?
No, sir, not at the moment.
Any other parties? No. Okay. Well, that's useful. Are there any other matters that you would like to raise? Perhaps, Mr. Gordon, is there anything finally you would like to raise or discuss as part of this meeting?
No, thank you, sir.
And Mr. Kelly?
Thank you, sir. In relation to responding to the matter of it being only Wildland Area 19 or not, I see in my diary that I have a scheduled email exchange with Wildland Limited on the morning of Wednesday the 20th. That's Wednesday next week. Would that be too late for me to reply on this point, or would that be adequate since it is a scheduled email exchange with them?
As far as I'm concerned, that would be reasonable. It's normally within 7 days we try to get the note out, but I think it would be useful for the purposes of the note to have that captured.
I can certainly do. Sorry, sir. The email exchanges are scheduled for first thing on Wednesday morning. I could get back to you, the case officer, by 10 o'clock on Wednesday the 20th.
That sounds absolutely reasonable to me, and the note of the meeting would then come out after that. I don't see any of the parties disagreeing with that. From the national park perspective, notwithstanding Mr. Finlay may have anything, is there anything you'd like to say, Ms. Caudry?
No, thank you.
Okay, Mr. Finlay.
No, nothing from any of my parties.
Mr. Trinick, finally, is there any other point that you would wish to discuss?
No, thanks, sir. No.
Okay, well, thank you very much for your contributions. The meeting has, so far anyway, it seems to have been effective. I hope you've been able to raise all the matters that you wanted to raise. I will take a note. I will also filter in the comments that consider the comments that have been made before. So the note will be a matter of matters arising from this meeting and the written submissions previously. That will, if you like, double up as a procedure notice for certain matters in terms of further written submissions, and I will work on a direction, and the case officer will be in touch with the applicant on that matter for additional information. Thank you for your assistance. I will probably leave it to the IT colleagues to formally switch the lights off, but I will close the meeting just now, and would normally wish you a safe journey home, but I know you're there already. So thank you.